Welcome. Please be seated. Was that the bailiff?
I think so.
All right, very good. Thank you. Welcome to the 14th Court of Appeals. My name is Justice Jerry Zimmerer, and to my right is Justice Charles Spain, and to my left is Justice Pagan Hassan. The 14th Court of Appeals is now in session, and we have two cases on the docket today. They are 14-20-00156CR and 14-20-00238CR, both titled Ex parte David Mark Temple versus the State of Texas. I believe by order of this court, we have granted a 10-minute extension to both sides. Is that your understanding, both of you?
Yes, Your Honor.
So that will be 25 minutes each. The appellant wishes to reserve any time for rebuttal, please let us know, or have you done so already?
I have already done so, Your Honor. I've reserved 7 minutes for rebuttal.
Very good, thank you. And if appellant wishes to reserve any time, I'm sorry. So today we have, if you would, go ahead and announce yourself and your parties, if you would, and announce ready.
Your Honor, I'm Stanley Schneider. I represent David Temple, and I'm ready for arguments.
Thank you so much.
Good afternoon, Your Honors. Jennifer Wissinger, representing the state of Texas.
Very good. And I assume you're ready as well.
I'm ready.
All right, thank you. Mr. Schneider, when you're ready, please begin.
This is unusual to be sitting down doing an oral argument. I've never sat down for oral arguments before. May it please the court. I'm Stanley Schneider. I represent David Temple, and the state of Texas comes to this court with unclean hands. And by that, I mean that the appellate litigation in this case has been ongoing for over a decade. The state suppressed evidence which resulted in a second trial. And but for that suppressed evidence, there's a likely outcome would have been substantially different at that first trial. And now we're here, and the state still comes to you and doesn't present the evidence that was presented at the trial and asks the court to find manifest necessity to granting the trial. The state also ignores one of the basic tenets of pretrial habeas corpus litigation is the necessity of consideration of judicial economy and the lessons that were written by the Court of Criminal Appeals in Ex parte Perry, where the court said that if the development of facts are clearly established pre-trial, then an as-applied issue or as-applied challenge to a statute can be considered in pre-trial habeas. And I don't know of a case, and I've been practicing law a long time, where the facts have been clearly developed in a record. In this case, we've had a trial where a substantial exculpatory evidence of innocence has been presented at a trial. And we have the state repeatedly saying, for example, at a pretrial hearing, in this case, Mr. Turner states, the state is allowed to put on circumstances of the crime so the jury can understand the crime. The defense is prohibited to introduce evidence of innocence. And the reason that a jury or the jury will not consider evidence of innocence is the change of law in 2005, which prohibits a retrial on guilt and innocence when you have a hung jury at punishment. So the change in law in 2005 changed the quality and what evidence can be presented to a jury at a punishment-only trial.
So, counsel, you're talking about the ex post facto claim, right?
Yes, Your Honor.
So let's talk about that for a second. What
Sure.
you've cited repeatedly to Ex parte Perry for your claim that we can consider this. We can consider
Yes.
an as-applied challenge at this point.
Yes.
So how does that support the argument? You know, the CCA has stated that pretrial habeas is not available in cases that are such as these, and Ex parte Perry involved governmental immunities and things that aren't really implicated here. So
what Ex parte Perry says, for situations in which the protection of the applicant's substantive rights or the conservation of judicial resources would be better served by interlocutory review, pretrial habeas jurisdiction exists. And they cite to Ex parte Weiss for that same proposition. And judicial economy is essential in this time of pandemic and unusual times. And what the state says in its brief is that what they want us to do is let the state put on circumstances of the offense, and then we make a proffer of proof of what evidence of innocence we want to put on. Well, the proffer of proof is the testimony that we set out in our brief, and that the judge has set out on the record saying this is what will be excluded. And what the state has says shall be excluded, it's all in the record. The record has been fully developed. So the court knows, and the court can find the evidence is also there. And so
the part of the record that has not been developed yet is what the trial judge actually does at the time of the retrial on punishment. Wouldn't you agree that trial has not occurred yet? So we can't say that absolutely what has happened in the evidence that's being presented or objected to or denied hasn't occurred yet.
The trial hasn't occurred. However, the judge has said this evidence shall not be admitted. The evidence of the Roberts boys hearing a gunshot at 4:30, the timeline evidence that's been litigated for 13 years, and the new evidence that was found. All of that is evidence that is on the record that the state says should not be admitted, the judge says shall not be admitted, and we know exactly what happened. So what the state suggests is, let's go forward with a trial on punishment, and let's consider only the circumstances of the offense, and all the evidence of innocence that has been presented, let's not consider it. And it's all there. And what the proffer of proof that would be made is the record from the second trial where all the testimony is already there. It's all been developed. The proffer of proof is in the record.
So wouldn't you agree that there's varying degrees of evidence that may or may not be excluded? For example, since the guilt and innocence has already been determined that your client is guilty, but the question of what evidence might come in might be the distinction between, well, there was a witness that says that a defendant was out of the state or even out of the country at the time of the offense. That type of evidence.
That is not admissible.
What's that?
That's not admissible. That is not admissible under 3707-3A. Alibi is not admissible.
So an alibi may not be admissible at the time of punishment. But yes, when you talk about intent or elements of intent, if that were to be denied, that's a different type of exculpatory type of question,
if you're dealing with self-defense, and I don't mean to cut you off, Justice Zimmer.
It's okay.
Dealing with self-defense. Self-defense is the circumstances of the offense. But when you're dealing with alibi or some other person did it, like we did in this case, we have both alibi and some other person did it. There are two different things. That evidence is not admissible because it's not a circumstance of defense. And we know that when the evidence of innocence is excluded, David Temple got a life sentence from a jury. When the jury heard this evidence of innocence, there was no verdict of punishment. And we know that the rules of evidence are different under 3707-3C than in 1999 is different than the rules of evidence that would be applied in 2005, and the evidence of innocence would be excluded under the 2005 amendment.
So Mr. Schneider, let me refocus for a second, because
sure.
What is the remedy that you are looking for here? Are you looking for a new trial and a new punishment hearing, or are you looking for the first issue that you've raised in your appeal, where we
Double
don't
jeopardy?
Right.
I'm looking for, I want the whole cake. And if we go to the double jeopardy, there's a number of fallacies in the state's brief and the state's arguments. On page 4 of the state's brief, the state writes, this trial resulting from the hung jury was not an event that terminated jeopardy. Hence, jeopardy is still outstanding. That statement is what permeates their entire brief, which ignores the language of 3707(3)(c) as it was written in 1999 and as written today. It says that no jeopardy has attached when a mistrial is declared at punishment, when the jury is deliberating in punishment. And the law is there has to be manifest necessity before a judge can grant a mistrial. And in this case, the issue of a fact of manifest necessity is not supported by the record. The state, in its brief and its recitation of the facts, on page 8 of its brief, it starts, the state's recitation says there's a note that says 2 jurors won't deliberate. And what should we do? The state ignores the rest of the record. And in that rest of the record, there are 2 requests that are made. The state requests that the judge determine whether or not those 2 jurors were disabled based upon the refusal to deliberate. The judge says that she would examine the law on that to see what the law was.
Focusing on that, Mr. Schneider, my question is, who had a burden at that point before the mistrial was declared in order for us to get to error, making sure there was preservation or on the part of the trial court? Is it your client? Is it the state? Is it the judge? I mean,
it's the judge.
Who had a burden to do something before the mistrial was declared?
The judge. And the reason I say the judge is the state made a request. Ms. Tanner made a specific request saying, Judge, maybe these jurors are disabled. Maybe we should determine whether or not they can proceed in following the law. That was a request by the state. And I made a simple request.
Was that denied?
It was refused. The judge ignored the request and said, I'm going to review the law, came back, gave an Allen charge, and took no further action. I made a simple request. Let me argue to the jury after you give the Allen charge. Let me talk to them. And the law says that a party can communicate with the jury with permission of the court. And that's what we were asking for. Is
I think the panel's familiar with that part, but on appeal, who bears in terms of trying to, who has the burden on appeal on the mistrial issue to demonstrate?
Well, we have to show that there was less drastic alternatives than a mistrial that were not considered fairly or reasonably by the trial court. And the record in this case clearly shows that there were 2 reasonable alternatives presented
proposed by the state, both of which were proposed by the state.
One was suggested by the state and one was suggested by the defense.
Okay.
The states requested determination whether the jurors were disabled, and I requested a simple argument.
I thought there was also a request that the disabled jurors might be substituted out for alternates.
Yes, Your Honor. If they were determined to be disabled, then they would be substituted for the alternates. And I sent to the court a couple of weeks ago the recent case of Gonzalez versus State, where Judge Keel wrote an opinion setting out the law on how to remove a juror during deliberation and why a juror could be removed for being disabled and unable to deliberate. And Gonzalez tells us what Judge Johnson should have done when the state made a request. And the state made a clear request to try to suggest to the court, these jurors may be disabled within the meaning of the law. And the court had an obligation at that point. The state has ignored that portion of the record. There's no mention of the state's request. There's no mention of my request for arguments. And a less drastic means could have moved the jury.
And I understand that that doesn't get you to the ultimate everything in the case, but is the fact that that both sides asked for something to be done before a mistrial and the judge granted a mistrial, is that enough for that argument to be over?
It's enough to preserve the record and require granting of our plea, because the jury at the end of its final note said, "We will continue to deliberate until you tell us otherwise." They were willing to continue deliberation when the judge granted the mistrial. So if the judge made that determination and had the in-camera review with the jurors and discussed the jurors what was going on, and the jurors said, the pressure is too great, I can't make a decision, and they were having an anxiety attack because of the impact of what they've heard, then they are disabled within the meaning of the law. If they said, in our conscience, I believe the punishment is X based on the evidence presented, and I've read the statute, and this is my verdict, and I will not budge, then they're following the law. But without the judge making that simple inquiry, she is not fulfilling her duty.
So to get back to the jeopardy issue then. So the state has argued that the jeopardy has not terminated after the guilt and innocence phase. Your position is different. So in your estimation, when does jeopardy terminate in this situation?
In this situation, I got to go to the statute. 37073C says, in the next to last sentence, in the event the jury shall agree on the issue of punishment, a mistrial shall be declared only in the punishment phase of the trial. The jury shall be discharged and no jeopardy shall attach. Now, that's the current statute. The statute in 1999 says, in the event that the jury shall fail to agree, a mistrial shall be declared, the jury shall be discharged, and no jeopardy shall attach. So the idea that jeopardy has not terminated as yet, and the state is, and that the state's position that jeopardy is still outstanding, is contrary to the statute.
So what does that mean? So how does that mean? What does that mean to you? Right? No jeopardy has attached.
Jeopardy again attaches when we pick a jury at punishment. So we have a second jury. Jeopardy is not attached yet, it's gone. So now we're dealing with double jeopardy because of what the statute says. And it's clear what the statute says. It's clear that the state can't have its cake and eat it too.
So you believe that so the guilt and innocence phase and the punishment phase are two different phases of a criminal trial, right? So does jeopardy attach when the first jury is chosen and seated, and then reattaches at the punishment phase? That's what I'm trying to understand.
Well, Justice Hahn, I've been trying to understand that myself. In the anomaly of Texas, our statute, traditionally, when a jury is impaneled and sworn, jeopardy has attached. However, when by statute now, when you have a hung jury of punishment, jeopardy is not attached any longer, and we have to go to the second jury to have jeopardy attached again. It's an anomaly of Texas law based on the clear language of the statute that was in effect in '99 and 2005. So I think that I think that answers your question.
Maybe.
But that's the bet. You know,
we might talk more about this when you come back. So
all right. Thank you, Your Honor.
May it please the court. I am Jennifer Wissinger, representing the state of Texas. The crux of this case is whether appellant can ever be sentenced for the murder he has been convicted of. Although appellant argues that this is a manifest necessity case, it simply isn't. However, either way, double jeopardy will not be violated by continuing to punishment in order to hold appellant accountable for the murder he committed. Thus, the trial court's decision to deny appellant's pretrial habeas writ should be affirmed. Further, his remaining claims are not cognizable here, and thus this court should dismiss appellant's second issue. Alternatively, this court should affirm the trial court's decision to deny the writ on that issue as well. Your Honor, getting right to the double jeopardy claim, we simply do not need to reach manifest necessity in this case because jeopardy has not yet terminated. It did not end when the sentencing mistrial was declared. Rather, we have a guilty verdict and we must finish the trial by continuing with the sentencing hearing. The state law requires it and double jeopardy does not prevent it.
So how do you work that with the language of the statute, the plain language of the statute?
Yes, Your Honor. So in the plain language of the statute, even though it says that jeopardy does not attach, I believe that is making clear that this does not become a double jeopardy issue. It is clarifying that when we have to redo the sentencing, that this isn't going to be an issue. It is confusing in one reading of it. If we read it literally that jeopardy has not attached, then we would not have a double jeopardy issue to discuss at all because jeopardy wouldn't have attached. It would not have started. And so surely that is not what appellant is arguing.
Be constitutional.
Sorry, say that again.
That even be constitutional for the statute to say that jeopardy just never attached?
No, Your Honor. I don't think it would be. So I do not think that that's what the statute could possibly mean. Further, Your Honor, the statute does also specify that when exactly what has happened in this case occurs, the court shall impanel another jury as soon as practicable to determine the issue of punishment. And so state law is clear that we need to continue with and finish this case.
Is there a substantive right that a defendant had prior to 2005 to have the jury decide both guilt and innocence and punishment? And if so, why does that not apply to this case?
Your Honor, there was not a substantive right to have the same jury. There was a procedural mechanism that caused that to happen, but it was not a substantive right. And so it would not be violated here. Further, as was discussed, it is the state's position that those claims are not cognizable here because we just don't have enough factual development in this case to get to that.
But you do have the court having entered an order granting the state's motion to exclude certain evidence at the punishment trial. Yes?
Yes, Your Honor. Notably, though, that was only a partial grant of that order. It did carve out a significant amount of testimony that was guilt innocence testimony that was presented that is still allowed to be in. Also, we still don't know what would happen. This order could change, or the judge's decision on what is considered exonerating or residual doubt evidence and what is considered circumstances of the crime. We just don't know what those decisions will be until we have the sentencing trial. There's just a large amount of discretion for the trial judge to make these evidentiary decisions, and we just can't guess what will happen. Or we could, but that is exactly what the limited cognizability of claims is here to prevent.
So are you as the state concerned that if you move forward on a sentencing trial, excluding all of this evidence, that this case might not come back and we might be faced with a double jeopardy at that point?
Double jeopardy.
In other words, assuming that he has a second trial on punishment, and this evidence that the judge has already indicated will not be admitted into evidence on that punishment trial, are you concerned that if they come back, that they may then come back on a double jeopardy claim at that time? In other words, after the punishment phase. And what would happen if the state objected to that, and if the state agreed, but the trial judge says no?
Your Honor, I believe your question is, if we move forward with exclusion of evidence and then that is reversed on direct appeal, if we would then be facing a double jeopardy issue if we had to do two more sentencing trials. Is that correct, Your Honor?
Yeah, it goes there. I think I'm more interested in kind of your thought processes. I do agree that those decisions have not been made yet, and that it would be hypothetical at this point. But I think there may be very legitimate concerns for a defendant who's in a punishment phase, that the jury hear all of the evidence necessary for them to have the opportunity to rule on punishment, the full breadth of punishment.
Your Honor, a large amount of evidence will be admissible. Any of the evidence having to do with the circumstances of the crime will be admissible. And additionally, there is just the evidence that's really being argued over today is the residual doubt evidence, and there's just no right to that evidence being presented.
What did you call it?
I understand the concern, though.
Doubt? Is that the word I heard, residual doubt?
Yes.
I kind of like that term. We don't really know at this point what the trial court may do. Is that right?
That is correct. We just don't know.
And so when you start thinking about cognizability, is that where you're going then?
Yes, Your Honor, that's exactly right. These claims are not cognizable, as most as-applied challenges are not cognizable because we just don't have enough factual development. And this case is not like the very narrow exception in Ex parte Perry.
Yeah, in Perry, that was focused on actually a legal issue, I think, as to separation of powers between the executive and legislative. Is that right?
That's exactly right, yes.
And that doesn't apply in this case?
No, that does not apply.
So let's talk about the mistrial. Who on appeal has the burden of bringing up proof for the necessity of the mistrial? Would that be the state? You have argued manifest necessity.
Yes. 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 We have argued that there was manifest necessity.
Okay. And so at trial, however, the state argued that there were less drastic measures. So
no, Your Honor.
Okay.
The state did not argue any less drastic measures at trial, other than the state did ask the judge to give an Allen charge, which the judge did do. The state did suggest to the judge that there may be a legal issue regarding disability that should be looked into to make sure that doesn't need to be addressed. So what the state asked the judge to do was to look into that legal issue. The judge said that she would upon retiring. We know from the habeas hearing on this issue that the state then went and did additional research on disability and determined that that was not an issue. Then the third jury note, making it very clear that this was a hung jury, came back. And at that point, the state did not mention disability again because it was no longer, it was clear that that would not be a less drastic means, that having a hearing to declare 2 hung jurors disabled in order for the state to get a verdict was not something the state was going to move forward on.
Okay. And so if, for instance, we agreed with the appellant that the mistrial was improperly granted, what would the remedy be for the appellant according to the state?
If this court agrees with appellant's double jeopardy claim, then the state would be barred from prosecuting, from ever sentencing the appellant for the crime.
And if we don't agree
and if you
with the double jeopardy claim, what if, I mean, so what is your remedy if we don't agree with the double jeopardy?
Our remedy is to continue with the sentencing, with the punishment phase.
Okay.
Your Honors, we have focused a lot on the cognizability of the claims other than double jeopardy, but briefly I would like to discuss the merits because it does appear that Your Honors are interested in that. Specifically, the focus of the prohibition on ex post facto and retroactive laws is protecting against an increase in consequences for acts committed prior to the law. Here, we simply don't know what the consequences are. And additionally, even if we did, it would not be a violation because appellant has not shown that this is the type of change that would be a violation. Specifically, we don't know what the effect will be, but this change is procedural. It does not change the legality of an action or increase punishment or decrease the amount or type of evidence required to convict. It's just not the type of change that's constitutionally prohibited. And Your Honors,
it's the kind of evidence that the defendant can bring in punishment.
It does not change the type of evidence that can be brought at punishment. The same evidence is admissible during the punishment hearing that it was before. Juries have never been allowed, or it has not been allowed to argue during punishment for residual doubt or the innocence evidence that appellant is arguing he has a right to argue. That has not changed. And if Your Honors do not have any further questions.
Well, I do. I'll have one. So, well, actually, I have a couple, but let's start with this one. You're familiar with the Utah case before the U.S. Supreme Court, where there was a change of the number of jurors that were allowed.
Yes, Your Honor.
What was the substantive right that was being protected by the U.S. Supreme Court in that Utah case?
Yes.
Is it a number, or is there something more significant to having 12 jurors versus 6?
Your Honor, I believe that was the Supreme Court case that found that it was an ex post facto violation to change the number of jurors, but however, that case was later reversed or was overruled by a future case. I do believe that case was focusing on the number of jurors specifically, but we know now that that is not, the Constitution does not necessarily require there to be 12.
Okay. And have you addressed the as applied arguments in this case? The as applied, that this was unconstitutional as applied to Mr. Temple?
Your Honor, yeah, I think it's difficult to address them because we have so little. We do not know what will happen. We do not know how this statute will be applied because we don't know what evidence will be entered. And that is the crux of the as applied challenge, as the state understands it, is that as applied to Mr. Temple, there is a different amount of evidence that will be presented. The change in evidence required for this stage of punishment has not changed. It is also, there's not a burden being met here. So it's not changing the amount of evidence required to convict. We're only on punishment. Any further details as how this would affect the appellant, we just don't know at this point.
All right.
So I'd like to just revisit manifest necessity for a second before we finish up with your section. And I guess I'm just having trouble understanding the argument regarding manifest necessity to order a mistrial when the trial court didn't inquire whether the jurors who refused to deliberate were disabled, didn't meet with the jurors to inquire what the problem were, and knew that there were two alternates who could have taken that place. So can you put that into context for us a little bit?
Absolutely, Your Honor. The less drastic means here was the Allen charge. The Allen charge cleared up or resulted in the third jury note. And that third jury note made it very clear that they were a hung jury and that this was not an issue of disability.
But they specifically talked about two jurors, right? I mean, so they had two alternate jurors. So how does that figure into the Allen charge being the only less drastic means necessary?
And they said they would continue deliberating.
They did. They said that they would continue, but they also said that severe violence had already been done to their conscience and that there was nothing more that they could do. So they were willing to continue deliberating, but they were clear that those deliberations were not going to go anywhere and that it was going to continue to cause severe violence to their conscience. While there were two alternate jurors, the state maintains that it would not have been less drastic or proper to start switching out hung jurors under the claims that they're disabled to get a sentence.
But do we have information in terms of, going into whether there was a disability? I mean, because we're talking about a potential disability, but could there not have been a less drastic step besides a mistrial in terms of looking into whether it was an actual disability?
I think what it is in this case is that third juror note just made it so clear that it was not a disability issue. It clarified the question that had been presented earlier about disability, and it clarified that these two jurors wouldn't budge. It was very clear to the trial judge that this was a jury that had deliberated to a point, and two of the jurors were no longer willing to budge from the position that they had gotten to in deliberations. It was just clear that this was a hung jury. And so it was not necessary, or I think advisable, to put the jury through additional violence to their conscience by putting them through a disability hearing.
So walk me through the process that could have been done in terms of trying to determine if there was a disability with those specific jurors. And maybe the trial court would have come to the conclusion that they weren't disabled after doing that. What would that process look like? As opposed to just looking at the note and going like, well, there's nothing more to do here, we're finished.
I believe, Your Honor, that it would have involved having to talk to the jurors additionally. But Your Honors, to directly answer your question, I'm not exactly sure, Your Honor, exactly what that would have looked like.
But there potentially is something that could have been done with, you know, and if it had reached the point where, okay, this isn't a disability, we're finished. Or there is a disability and we can call the alternates in.
I think that from our position, it may feel unclear, but from the trial judge's position, it was not unclear.
But there's nothing.
The fact that
the trial judge says that is there explicitly that there is no disability. We're just speculating how the trial.
We are, but what we should do is give discretion to the trial judge's decision that she was in the room. She delivered the Allen charge looking at the jury in the room. That is in the record. She saw their demeanor. She saw all the jurors during the deliberations, and she's just in the best position to determine if disability could have been an issue or if it was correct to issue a mistrial because this was a hung jury.
But there is nothing explicit in the record regarding whether or not she considered any kind of disability. And so we can, in fact, infer from the record a number of different things. But if the record is silent as to what her contemplations were, it's difficult. It's more difficult for us to infer that. Wouldn't you agree?
I think it is, but I think that it is implicit in the record that it was considered. The state did bring up disability before the third note. The trial judge said that she was going to go back and research it. The state did additional research. So it is implied on the record that disability was researched and was considered. And while there was not a hearing held, I think it's implicit on the record that that's because the judge, based on her review of the law, made that was the right decision based on her experiences she could see.
And counsel, you keep referring to 3 notes, but I only recall 2 in the record. Is that am I misremembering?
No, Your Honor. There are 3. There are 2 that are most pressingly at issue here. So when I say 2 and 3, that is probably you're thinking 1 and 2. So I do apologize for.
Just wanted to clarify
for the miscommunication. Yes, there was an earlier jury note that was sent, but it's not necessarily at issue here.
But the fact that a judge, you know, goes and does research on the law, and there's nothing on the record that shows what they did, and the law is the law. I don't know that necessarily, the fact that they went and looked something up bolsters what happened.
I don't think the decision was wrong, though, Your Honor. Further,
I'm not suggesting one way or the other. I'm just saying the fact that research was done into the law to me is a neutral. I mean, I don't know that there's anything on the record that shows that a specific disability issue was inquired into and rejected for factual reasons. I mean, I think we'd all agree whatever the law is on disability is whatever the law is on disability.
Well, I'm not so sure. Is there a distinction between a hung jury and a disabled juror? I mean, I'm not sure that there was actually evidence of a disabled juror in this case. So how would that impact our conclusions?
I agree with you, Your Honor. I don't think that there's evidence showing that there was a disabled juror. I think that a hung juror and a disabled juror are 2 different things.
So assume with me that these were not disabled jurors, just hung jurors. Would it have been appropriate for the judge to then pick 2 out and substitute 2 others in?
No, Your Honor. It would not have been proper to substitute in hung jurors. And Justice Spain, to address your last question, I think it's important to note that no rigid formula is required for finding a mistrial, and no explicit manifest necessity finding or reasoning is required on the record. However, as I've discussed, I do think that there are implicit evidence in the record that supports the trial court's decision and supports that this was a hung jury, and the mistrial was correct because there was manifest necessity to declare it. Your Honors, in conclusion, for all these reasons, the court should affirm the trial court's decision to deny appellant's pretrial habeas writs because double jeopardy will not be violated by continuing the sentencing phase to hold appellant accountable for the murder he has been convicted of. Thank you, Your Honors.
Thank you. Mr. Snyder.
Technology. There are a lot of issues I want to cover. First, a question was asked about what evidentiary considerations are different post-2005. Prior to 2005, if a mistrial at punishment is granted, a jury would consider all the evidence of guilt or innocence, all evidence of innocence, alternative suspect, self-defense, alibi, all those issues would come into evidence at punishment. And a person could argue, if convicted, residual doubt, like I did in this case. My punishment argument was a residual doubt argument. Without the evidence of innocence, that residual doubt argument cannot be made, and evidence of alternative suspect and alibi are not admissible. The evidence is clearly set out. The state's objection to evidence is clearly set out, and the trial judge's ruling is clearly set out. All the evidential considerations are there. In regards to the application of Perry, it wasn't a procedural issue involved in Perry. As the court said, a key unresolved fact, according to the state, is whether the acts constituting misuse of the funds for the Public Integrity Unit is the governor's veto. The indictment does not specify the act of misuse, although the state's bill of particulars specified that the misuse was the governor's veto. The bill of particulars set out the facts necessary for the court to address the issue. And so it was a factual determination, not a procedural determination.
But the issue was whether or not the exercise of that veto was an official duty, wasn't it?
Well, it was a misuse of his duties. And that was the question of fact that had to be developed evidentially. And the bill of particulars set out those facts. Now, the state, again, has misrepresented the record that has been presented to you concerning when the mistrial is declared and the state's suggestion. On August 8th, 2019 at 4:50 in the afternoon, and that note is attached to our brief, the jury sent out its first note. The jury was sequestered and came back the following morning with a note. Judge, 2 jurors will not deliberate. What shall we do? It's at that point the state made the request for determination of whether or not those 2 jurors were disabled. That required a hearing. That required an inquiry by the court. There was no inquiry. I then made the request for arguments. That's preceded, these events preceded the Allen charge. After the Allen charge, I objected again to not allowing me to argue. There was no manifest necessity. The judge should have made an inquiry if the jurors were disabled. And Justice Zimmer, if they said, we believe based on our view of the evidence in the charge that we should hold out for whatever they wanted to hold out for, then they're not disabled. If they say, if the jurors based on inquiry says, I can't function, I can't go forward, the pressure is too great, just like the juror in Gonzalez. The judge had, we see in Gonzalez, the inquiry the judge made as to what was going on with that juror. The judge was patient and listened and handled a juror who was suffering from anxiety with kid gloves and said, thank you for your consideration, and replaced it with an alternative. That's what should have happened. So if the juror is disabled, you replace a juror with a alternate. If both jurors are disabled, you replace both of them. But you have to make the inquiry the state requested. And if I made an argument, could I have swayed those jurors in 1 minute, 2 minutes to reach a verdict? We don't know, because those requests were made. And we know the law is clear in Texas that the judge could have removed either or both of those jurors.
Assume that we agree with your argument that the judge should have. But was there a requirement that was there an actual obligation of the judge to do that?
Yes.
Where do you find that?
The Supreme Court has said it in the United States, the Court of Criminal Appeals has said it, that if there is a less drastic alternative to a mistrial, then the granting of the mistrial is wrong, is abuse of discretion.
So focusing that, I understand that that's what they've said. If the state says we should look into whether someone is disabled and the judge does nothing and there's no other explanation for it, does that mean the mistrial is no good?
Yes.
Period. End of story.
Yes. And the one of the questions that Justice Hassan, you addressed about the statute interpretation. Jeopardy attached when the jury was sworn. By statute, there is no more jeopardy.
Well, when does it terminate, though? Isn't there a distinction between when it attaches and when it terminates?
If it's no longer attached, it's terminated by the granting of the mistrial, and it starts again when the new jury is set by statute. You have to interpret the statute based on its plain reading. The plain language of the statute that has been carried on forever says no jury jeopardy has attached when the mistrial is granted. That's what the statute says.
It wouldn't implicate double jeopardy then, because no jeopardy had attached at that point.
At that point, once the ruling, if you find that there was no manifest necessity, that the judge abused his discretion in granting the mistrial, then it would implicate double jeopardy, because it prohibits the picking a new jury and having jeopardy attach again. That's the meaning of double jeopardy. And it just, that's the essence of it all. The court.
Sorry.
Yes.
So then, the jeopardy analysis, you're basically trying to say that the jeopardy analysis is the same at the guilt innocence phase as it is at the sentencing phase. That they're separate, but they're exactly the same.
Yes, when a mistrial is declared, all of the cases in the state's brief, all of them deal with issues of what can be considered a punishment. Error in punishment and new trial is presented for punishment consideration. There are no cases dealing with mistrials at punishment. And that's what we're dealing with here. When does a judge grant a mistrial? Is there manifest necessity? Must there be manifest necessity? And what Gonzalez tells us is when there's a problem with a juror, the judge has a duty to make inquiry to find out what's the problem. And it's the judge's duty, not our duty to do it. It's the judge's duty. And Gonzalez tells us what the law is. And the judge here did not follow through on the state's request, did not follow through on my simple request. There was no manifest necessity before the mistrial was declared. It's clear on the record. And the state has refused to even acknowledge in their brief that they made that request, or I made a request for arguments.
Are there any cases that would analogize if someone talks about disqualification of a juror? Have you seen any, like the suggestion that the defendant lacks competence to where you have to do something?
I think, Justice Spain, the reason I referred the court to the Gonzalez opinion that Judge Keel wrote from the Court of Criminal Appeals a few weeks ago, that has one of the best analysis of when a juror is disabled and how it applies, and what procedures should be followed by a trial judge in determining whether a juror is disabled or whether the juror is conscientiously following their conscience and applying the law in the court's charge. Because if they're following the law and following the court's charge, they're not disabled. But if they're incapacitated, they're frozen in place, then they're disabled. And without the inquiry that the trial judge in Gonzalez did, you don't know. And you can't tell what it is. And you're left to speculate. You're left to speculate what impact an argument could make. And that's what we have here, is a situation where a jury was sitting for 18 days, I think it was, 20 days, and had been deliberating for over 20 hours. And some requests were made that were simple to follow, simple to see that David Temple had his right to a single jury declaring guilt and punishment. And that's what his right is. And that's all we asked for. And the two taken together, if we follow the state's suggestion, the litigation in this case is going to outlive all of us. Because we'd have to have a second trial, a direct appeal, because there's still been no appeal of the guilty verdict. That's still pending. So I'd ask the court to find that there was no manifest necessity for the mistrial, apply well-stated law, apply the rationale of Gonzalez, and find a double jeopardy bar to the retrial. Thank you very much for your patience.
Thank you.
Thank you very much. All right, and you too. All right, folks, let's see. Cause number 1420-00156 CR and 1420-00238 CR are both submitted. And the 14th Court is adjourned with your thanks for a very interesting case. Thank you both.
Thank you, Your Honor.